Good afternoon, members. Again, the chair is absent this afternoon, so could I have a nomination for someone else to fill in as chair for the meeting?
I nominate Annabelle.
Any other nominations? All in favor, please say aye.
Aye.
Carried. Ms. Bell, please take the chair.
May I have name tag will travel? I recycle my jokes too. All right. Thank you very much. Welcome to the Special Committee on Government Records Retention. It's Friday, November 6th, and this is the second meeting that we've had today for this. So, welcome to committee members. And if I can have a motion for adoption of the agenda, please. So moved from Corey Deagle.
So why don't we just, I take all this one? Sure.
Mm-hmm.
Sorry, Jim.
That's okay. So just give you a chance to have a look at the agenda, and then so the adoption of the agenda has been moved by and approved. So because we're following on from a committee meeting that we had earlier, I'm not going to read the record again of the motion. I think we know what we're here for. So what we can move straight to is item number 3, review of records management matters as discussed in Information and Privacy Commissioner Order number FI 20007. And we have Erin McGrath-Gaudet with us today, Deputy Minister of Economic Growth, Tourism and Culture. And I think you have a presentation.
Sure. Yes, yeah.
So what we can perhaps do is, if you'd like to do your presentation, we'll hold questions to the end, if that's the will of the committee, and then we'll be opening up the floor at that time for questions. And the occasional drilling. Okay. What did you have for lunch? Yeah. For those following along online, there's ongoing construction in the Coles building, and we get some really random noises every now and then, and we have to remind them of when we're in session so they can stop with the random noises. So I think the clerk has, yes, okay, we're good to go. All right, so if you'd like to start your presentation, that'd be great.
No,
thank
wonderful. You. And certainly thank you for the opportunity to come and speak to the committee today. I know in particular the committee wanted me to speak to the particular order, the Privacy Commissioner for its order FI 20007, as it relates to the department that I'm currently the public body head for. At this point, I understand you've had some presentations already from the former and current privacy commissioners, representatives of ITSS, as well as the employees who his records were subject to these particular requests. So I will attempt to not duplicate too much what was already said. So I'll probably leave most of the time for questioning. I will perhaps just walk through what a typical FOIP request looks like from the department's perspective and walk through some of the matters related to these particular 5 requests and the order. I may have to take some of your questions away. I did assume my role mid-May of last year, so some of these matters do predate me, but I'll certainly do my best to answer any questions that you have, and if there are some items that I need to take away to get more clarity on, I will endeavor to do that. So just to start with what a typical FOIP request process looks like from a department's perspective. So as you can probably guess, at some point we receive a request that comes in to our office. So I know earlier there was a question related to whether or not we receive the name of the applicant or at what stage that becomes apparent to us. So all of that information does come in through the APSO office, and then by the time it comes to our department, basically we just get an email from APSO that has the body of the request in it, so it wouldn't have any of the tombstone information about the applicant or any of that information. It would simply be the text of the request. So the request is for records pertaining to a specific initiative or correspondence between certain individuals is what we get on our end. And then based on the request, we will assign the request to an appropriate searcher. So whoever would be the most likely custodian of that particular record. And I will say, if necessary, there will be some back and forth between the department and the applicant via APSO. Just in some cases, there may be clarity that's needed about a specific request. We may call it something internally and someone may be requesting for it, using different terminology, and we just want to make sure that we are understanding what they are looking for. And in some cases, we may see if the applicant wants to narrow their request. So one of the things that we do have the ability to do is if it's a large request, we could do a fee estimate. If we think the hours for the amount of search time it would take or the number of records would be beyond what a certain threshold, we could go back and provide them with a fee estimate. But I also do like to give people an opportunity to narrow a request if it's quite broad, because in some cases they may just not understand how broad the request is. It may seem quite simple to them when they make the request. So we will typically, if it's going to be a larger request, provide an applicant with an opportunity to narrow that request. And then once we have that settled, and again, that all goes through APSO, so at no point would the public body be communicating directly with the applicant. We would be communicating with APSO, and then APSO would be communicating with the applicant. And then at that point, once we have that clarity or we're definitive that this is the search that we are conducting, the search would take place. Typically, it is administrative staff that would perform the actual search, but again, that would depend on the type of request. And some requests, we actually would have multiple people conducting different aspects of a search. But each searcher would complete a form that indicates where they searched for records. They would also flag if there were any concerns with disclosing those records, and that would come up to my office with the stack of records that they had retrieved. And at that point, we would send them to APSO office to be processed. So it's the APSO staff that would be scanning all those documents. They do review them as they scan them as well. I typically look at them before they go to APSO, but they would scan them as well as they're going into the system. Some of the things that I know both myself and the APSO staff look for would be things like third-party material. So some of the records that may be requested may relate to an individual or an individual business, and that's when we have to look at the protection of privacy side of that legislation as well. So if there were records related to an individual, that we would provide that individual with a copy of the records, say that they were part of responsive records for a request that was made, and provide them with an opportunity to object on certain grounds if they don't want those records disclosed. So that's kind of the third-party review stage. And then we would also look to apply protections. So regardless, if it was personal or private information, sensitive business information, anything that would be solicitor-client privilege or advice to officials, we can redact those portions of a record. So a typical one may be, an individual cell phone number, anything that would be about net worth statements, things like that would come in, that we would certainly apply some protections to that type of private information. And that's done collaboratively between the head of the public body and APSO. They would make recommendations. In some cases, we may engage legal services through APSO, who I believe you have had an opportunity to meet with as well, just to make sure that we're applying protections appropriately. But ultimately, at the end of the day, the decision does rest with the public body, so it would be ultimately my decision to make as to what protections we're applying. Then once we have all of those protections kind of settled for a request, APSO would draft, it's a fairly standard form letter back to the applicant and send it to my office to sign off on with the records that would then be released to the applicant via APSO. And that's actually the first time that I see who the applicant is, just on the form letter that they send up. So all of the other pieces, any of the other communication, and actually even right up to that final, even though I know who the applicant is, the communication happens via the APSO office. And then I'll just walk through the review process as well, because obviously that's where this order kind of comes into play as well. So applicants, when they receive the decision letter from the department, and actually third parties as well, so if I were to send a decision letter to a third party saying we're disclosing these records, each of those form letters does include information about their right to request a review from the Office of the Information and Privacy Commissioner, and timelines and contact information to do that. So obviously in this case, the applicants for these files had issued or gone to the Privacy Commissioner and requested a review of those files. If a request is made to the Privacy Commissioner, the Privacy Commissioner does follow up with our office to say, we have had a request for a review of this file. They do provide us with a copy of the request, so if an applicant sends a letter or an email to request and they actually, I believe they have to do it in writing anyway. So we would be provided a copy of that submission that they just made and what grounds they would be asking for a review. Typically, the Privacy Commissioner may also ask us some questions of her own. I can say her own because it's been a former and current are both females. But the Privacy Commissioner would ask potentially some questions for us as well around our processing of those records. I suspect that would depend largely on the grounds for which somebody is asking for a review. I do have the assistance of APSO Legal Services in conducting, drafting submissions back to the Privacy Commissioner. And, typically that would be the forum where we would coordinate the search would be through the legal services on that as well. I believe, as has been alluded to previously, that you are aware that the department and the applicant always have the opportunity to respond to submissions made by the other party. So this can create a long process. I mean, as you can imagine, if we're going back and forth multiple times with different submissions responding to the submissions made by another party, then it can certainly drag out on that respect. But we're always given the opportunity to respond to submissions made by an applicant or a third party. And then once submissions are complete, both ourselves as the public body and the applicant or the third party says, we're done making submissions, that is when the Office of the Information and Privacy Commissioner would deliberate and then ultimately issue an order at the end of the day. So then I'll move in a little bit to this particular order that was made by the Privacy Commissioner. So this was 5 separate requests that were made to the Department of Economic Development and Tourism / then became Department of Economic Growth, Tourism and Culture. It was two separate applicants, but all related to the records of one particular government employee. The requests had come into the department between November 2018 and February 2019. Disclosures were made back to the applicants between December 2018 and May 2019. And then requests for reviews were made based on the applicant's questions related to the adequacy of the search conducted. They had stated that they believed more records should exist. And so that was the basis of their request for a review by the Privacy Commissioner. As I indicated earlier, I kind of came into the picture as both in terms of coming into government, but also coming into the role of the head of the public body mid-May of 2019. So 2 of these requests were kind of sitting there for me to deal with when I first came into office. Searches had been conducted at that point with them, but final sign-off on that disclosure was necessary. At that point, I will say I did have briefings with both, the staff on FOIP requests, so I understood the process, asked some questions about the records that were to be disclosed as part of that, the process for which things were searched, and the records that were found. But I will say we did have some prescribed timelines that we did to meet. We were late in getting those records out the door by, I believe, a few weeks at that particular point, just because of transition. Unfortunately, or fortunately, depending on your perspective, the FOIP Act does not give us a lot of leeway on, transitions of government or holidays or even pandemic. So even during the pandemic, there's no allotment for we can be late because of extenuating circumstances. We do have timelines that we are expected to meet. And at that point, like I said, 3 of these files were already into the review stage. Those 2 final ones that I had signed off on. We did then go into some of these submissions that you would have heard about back and forth with the Privacy Commissioner. I certainly had a number of conversations with ITSS to understand, what steps had been taken to date to try to recover the records, what we knew about why we couldn't access them, and if there were any additional steps that we could take to retrieve or rebuild that archive. And I will say they were wonderful. They did walk me through some of the steps that have been taken to date. Unfortunately, they had told us at that point there was no other step that we could take easily that would recover those records. As I believe has been shared in the past, if there were kind of some specifics of, that an individual knew that there was an email between them and another government employee around this time, They could go back and potentially rebuild some of that, but to just do a blanket across the board rebuild of the archives was not possible, given the options that they had at their disposal. And I will say ITSS also not only responded to me, but did assist us as well in the review process with the Privacy Commissioner, both in terms of answering written questions, making themselves available when there were questions from the Privacy Commissioner. I've sat down with the Privacy Commissioner and did respond to inquiries that way. Also, the employee whose records were subject to the review did assist us as well, answering questions both that I had, also the Privacy Commissioner had, so that we could respond to the applicants at that point. As you know, at this point, the Privacy Commissioner did rule that we had conducted an adequate or a reasonable search, that for the records that we did have, we had conducted a reasonable search. But her ruling did indicate that basically we should have disclosed at that initial stage that there were gaps in the records, so that there may at one point have been records that we just simply cannot retrieve right now, but that basically that premise should have been disclosed to the applicants off the bat as opposed to coming out through the review process. I did also just want to provide you with a little bit of context about, some of the steps that we have taken to date. Although, as you know, at this point, none of these steps were successful in terms of recovering an archive. But I did want to let you know what we've done to try and mitigate some of this. So obviously, as I've stated, we did involve ITSS in an attempt to recover what we could from the archives. In some cases, they were able to do that if it was a very specific or, there was good knowledge about what the record was and where it would exist. They were able to assist us on at least one occasion with that type of a record. We did, and this was actually something my predecessor had implemented, start a practice of duplicate searches. So where we knew that there were gaps existing, we would have someone else also conduct the same search. On one instance, it did come up with an additional record that wasn't found in the primary search, but again, it was mostly just done so that we could validate the results and make sure that there wasn't human error in factoring into the gaps as well. And then finally, where it was appropriate or where it was possible, what we will do, and we still will do this, is search from an area where there are more complete records. So for instance, if a request came in for correspondence between employee X and employee Y, where we know employee X may have some gaps in their archive, we would ask employee Y to conduct the search with the assumption and the understanding that their records would be more complete, so we would have a more complete response. And certainly as we've gone through, we will be taking steps, when we run into this type of a scenario in the future, if we run into this type of scenario in the future, to make sure that we are, at that outset, providing open and accurate and complete information back to applicants at that outset. So it's not just about the search that we conduct and making sure that we have all the records we can retrieve, but that we are communicating as openly and completely and accurately as we can with applicants. So with that, that does wrap up the prepared presentation, but as I said, I did want to provide lots of opportunity for questions. I'm happy to take them.
Okay. So we're on the list. I'll start with Gord.
Thank you for your presentation. That's wonderful. You had mentioned the period of transition. What, in your mind as a deputy minister, what can be done better during a period of transition in the future around disclosures?
I would have to give that one some thought. I mean, frankly, when there's going through a transition anyway, there's quite an offloading and unloading and uploading of information during that time. FOIP would be a small fraction of it, frankly. So, I mean, there were those files that were sitting there. I did have opportunities to talk to staff and make sure that I understood what searches had taken place and feel confident that the records had been retrieved, that we could at that point. But I'd have to give more thought in terms of if I had advice for next time there's a transition, what it should look like.
Gord?
You said we knew that should have been disclosed, and there was that you knew that there was gaps in the record. But they came out in the review. When did you come to that conclusion that you probably should have disclosed something prior to it was being disclosed?
It would be kind of a topic of conversation. So in terms of being aware of the gaps, I will say the employee in question was very forthright and open with me that he had experienced gaps in his archives. and also, that we had that kind of duplicate search being conducted just to make sure that we could eliminate any human error. One of the things that I had done was even just look back on files to make sure that the types of letters that we were sending out, because as I indicated, I had signed off on those first, or 2 of those 5 disclosures. The letters that we were sending out, they're fairly standard form, and I think in most cases that would be fine. I don't know that anybody had come across a scenario in the past, I'd had to check, as to finding gaps and not disclosing them. Typically, I know there were some instances where there were no records found. So as a for instance, and I know you spoke earlier today with 2 individuals who their archives were completely gone because their accounts were deleted. That would have probably been disclosed to applicants. I'd have to go back and check, but certainly in the previous few that I had looked at when I was making that initial decision, they are fairly standard template letters, so there was nothing out of the ordinary that I had flagged initially in terms of the letter I was signing versus previous ones.
I guess we're focused on trying to make things better. This committee is trying to make things better. So what advice can you give the committee based on this particular experience to improve records retention and management within government?
Well, I will say in this instance, we still don't really know what exactly happened to the records, so it would be difficult for me to offer a solution to this particular issue. Certainly since the time that these records were created, and frankly since the time that even the Privacy Commissioner, the window that she had indicated for when they would have gone missing, there have been a lot of steps to improve records retention. One that I believe the ITSS had mentioned is, no longer can employees have archives on their hard drive or on like a USB stick. They're all on the network. There's a lot of auto archiving that does happen now as well, that the way our systems are set up, that, so there have been improvements on the electronic side, and I'm not an IT expert, so beyond that I probably wouldn't be able to provide too much advice. But I will say internally we are spending a significant amount of time on records retention and training. I know a lot of our staff is going through that right now, and just having even some refreshers to try and do the best job we can in terms of retaining the records that we do have.
As a new deputy minister, are you surprised that how many requests have you seen as the deputy minister since you've been there come across your desk, and is it an overwhelming amount, and how much time do you spend on it?
More than I would have guessed when I started the position. I could certainly go back and get the numbers of the requests that we do have. I will say there's quite a varying degree of complexity with them. I mean, we have some that are 1,800 records. We have some that are 5 pages. So, certainly there are some. I wouldn't just chalk it up to the sheer number of requests, but it really is. Some of them can be quite complex, and some can be quite simple.
Thank you, Chair.
Okay, thank you. Peter Bevan-Baker.
Thanks, Chair. Thank you, Erin. Can you just, obviously part of the complexity here is that this issue sort of straddled 2 administrations, and you've talked a little bit about the challenges of being a new deputy head and the head responsible for records management in EGTC. And I'm wondering if you could tell us when you first became aware of you mentioned, I think, that there were 2 files on your desk when you came in. Was that 2 of the original 5 requests that came in?
Yes, yeah.
Okay. And when did you personally become aware that, whether in the original responses or the responses that came from your time in office, that you had not divulged to the applicants that there were records missing? When did you discover that?
Well, to be honest, it really hadn't entered my mind about whether or not that should have been a particular issue disclosed at the outset initially. And, that can be a failing of mine as well. As you can probably guess, those early days, you have a lot of stuff coming at you very, very quickly. We did go through a process through kind of end of May into early July where we were working on the review process. And we were doing a lot of back and forth with the Privacy Commissioner, ITSS as well, and the employee whose records were the subject of the FOIP to respond to those. So, at that opportunity when we were in the review stage, it was that July submission back to the Privacy Commissioner where we did disclose that there were records missing. So that, again, the Privacy Commissioner's order told us that we should have indicated that at the outset with the decision letter, but in terms of the process from myself, that was when that disclosure was made back to the Privacy Commissioner that there was that gap that existed.
Peter Breton-Baker.
So, thanks, Erin. When did you become aware that the records, because we know back in February the department knew that those records were missing, that there was a gap.
February of
I'm sorry,
2019.
in February in 2019.
Okay.
And yet the applicants were not made aware of that missing information until July of 2019. Where in that span of 5 months did you become aware that the records were not, that information had not been provided to the applicants?
It would have been late May. Certainly as I was discussing with staff before I had signed off on those initial letters, I will say that staff were quite upfront with me in terms of the fact that there was a gap. But in terms of the discussion of disclosing that, it would have been just after we had signed those decision letters and we were discussing the review process that was already underway for those other 3 requests.
Peter
Sure.
Breton-Baker.
Thank you. So staff made you aware that there was a gap, but you chose not to include that in the report back to the applicants?
In those, as I kind of indicated earlier, those decision letters, I did look back to some previous ones. They're very standard form letters. So to be honest, it really hadn't occurred to me at that particular time that we should amend the form letter to disclose that. It really was during the review process that we were already in on the other 3 files that was a discussion.
Okay.
Peter Breton-Baker.
So I want to read, because there were 2 sections in the Information and Privacy Commissioner's report specifically related to the failure of your department under Section 8 of FOIP to provide open, accurate and complete records. And there's Section 47 and 48 of her report. So I'm going to read a little bit from Section 47 if I could find it here. She says that you, in Section 47, that your department did not provide open, accurate and complete records. And I'm wondering why.
Well, I will say it wasn't that we didn't provide the records. So it was the communication with the applicant.
Right.
Correct?
The communication
Yeah.
that there was a gap in the records.
Yes.
Yeah.
So,
which would be part of the completeness and the accuracy of your response.
So just in terms of your question,
Yeah.
because you kind of read the statement, but
Yeah, I'm trying to understand why you did not provide that information to the applicants that there was a gap in the records when you first found out in May.
again, hindsight is always 20/20, and absolutely, if I were to go back and do this again, I mean, now obviously having the ruling of the Privacy Commissioner, that would be something that we would now disclose to an applicant. The first stages that I took, again, were to kind of look at what the standard responses back to applicants looked like, what I was provided with in terms of the form letter from APSO was in keeping with what the practice had been. So in the interest of meeting the timelines back to the applicant, and again, we were already late, frankly, to respond back to that applicant. That is why we moved ahead, or I made the decision to move ahead with the letters as they were presented to me. And then again, we were into that review process at that point, and disclosures were made very shortly after that through that review process as well. So I don't have an excuse or an explanation as to why I failed in the first place on this. So I'm sorry, I don't have a neat answer for that. But we do learn as we go, and certainly that's something that we endeavor to do and to do better next time.
Okay, thanks. Chair.
Peter Breton-Baker.
And in Section 8, the Privacy Commissioner, and it's sort of quite heated language for a report from the Privacy Commissioner. She says, I was at a loss as to why the information was withheld. And I've asked this question a couple of times. You said, well, you just essentially, and forgive me if I'm misrepresenting and correct me, but you just did not feel that that was a necessary thing to include in your review. Is that fair?
It wasn't standard. So again, kind of looking at, those early days, we were looking at what kind of the standard response was. Those letters were drafted, for me by APSO. I viewed them as being more expert in this area than I was in my first 3 or 4 days in office. But yeah, hindsight, being what it is, and certainly having the Privacy Commissioner's ruling, that is something that we should have done in those decision letters.
Chair?
Peter Bevan-Baker.
So I'm interested in the discussions and the relationship that you would have had as head of department with APSO. And I think you said in your presentation, and again, I may not get this exactly right, but APSO legal assists in drafting and preparing the responses.
Yes.
And when we had the head of APSO here, she said exactly the same thing. So I'm trying to get through in my own head the response. Is that something that is written initially in your department and then you present it to APSO, or does APSO write it and then you sign off on it?
So you're thinking specifically of the review process at that
Yes.
point? Typically, they will take the lead in terms of drafting, and then, but ultimately, at the end of the day, the decision is mine as to what we do release.
Right.
Peter Bevan-Baker.
So, yeah, clearly you have to sign off on it as head of department for records. So, in a case of a review, APSO would be the ones who would take the lead, as you say, on actually writing the report. Which
And communicating back and forth with the Office of the Privacy Commissioner, yes.
Okay, all right. And I think, and I wasn't here this morning, of course, but I know there was some discussion with a couple of previous staff members regarding the deletion of emails. And I think it's been said in this committee before, but I think it bears repeating that that standard practice of keeping emails for 365 days and then them being permanently deleted from files, that is a very separate thing from the obligation of an employee to maintain a record if an email qualifies as a record regarding a decision or something like that. So even if your files are deleted after 365 days, it's the obligation of the employee to recognize that a particular email may qualify as a record. And I'm just wondering what sort of information and what sort of RIM training your employees receive when it comes to the necessity to retain a record, regardless of the fact that their email account will be deleted.
So for clarity here, so it is not our practice to delete emails after 365 days. So there is a backup that is held within ITSS for 365 days. So should I accidentally delete something, they would have a copy of that for 365 days that I could go to them and say, I accidentally deleted this. Are you able to retrieve it for me? So there's that side of it. But we do have email archives that we do retain all of our email records regardless of any particular time period. The only records that are, like in terms of emails that are eligible for deletion would be transitory records. So I get newsletters or job notices and things like that. I can and do delete those types of records. Everything else, though, would have to be retained and filed.
Sure.
Peter Bevan-Baker.
Erin, can you inform the committee, and we did have a presentation regarding the various departments and the levels or the rates of employees who had gone through RIM training. And I'm wondering if you, off the top of your head, know what the completion rates for records information management training?
I'd have to go back and look at that. We do have a push on right now that across government we have requested all employees who hadn't completed it yet to do that, I think by mid-November. So, certainly my hope by the end of November would be that it would be significantly higher than what we would have last had, so.
Okay. Chair?
Peter Bevan-Baker.
Thank you. In paragraph 79 of the Commissioner's report as well, it's a little ambiguous, and I want to ask you a question on that as to whether or not your department actually has a disposition schedule in place. I think the wording she uses, the public body continues to work on addressing the concern that there isn't one in place. So does that mean that EGTC still does not have a records retention schedule?
There are pockets of the department that do have them in place and are following those. There are parts of the department where they are not in place and that we've been working on getting those sections of the department up to that point. But nothing is deleted without a retention schedule. So if anything, I would say the department probably errs on the side of hoarding too much information, but nothing can be deleted with or disposed of without that records retention and the approval of that records retention schedule.
Going back, and I should have asked this question at the very beginning, Erin, but who was your predecessor as head of department in the previous administration responsible for records?
For the department or responsible for records retention?
Well, in your role as head of department relating to records, who?
It would have been David Keedwell,
Okay.
the former deputy minister responsible for, it was economic development and tourism at the time.
Sure. Thank you. Can you tell us what, if any, impacts COVID has had on your ability to process and manage records, access to records requests?
It's not been without its challenges. I would say the ransomware attack probably created more challenges because for a period of time, staff didn't have access to their G drive, so the network drives. With COVID, we did have staff working from home more. So, there has needed to be some, VPNs put in place so that they could access G drives and such. But certainly in terms of retaining information, it's been not a significant challenge. I mean, it is an extra step sometimes that we do have to take to make sure that paper files, once we get back into the office, are complete and those types of things. And I know in one case we weren't following the records and retention schedule because we could have actually destroyed some documents by now, and that just, in the middle of COVID, destroying documents wasn't our top priority. So we do have to catch up on that particular piece.
Peter Bevan-Baker.
We know that the number of applications through FOIP is going up quite substantially, and I'm wondering whether your department keeps stats on how many requests you get on average each year?
APSO does keep track of all that. I mean, I can access them easily enough, but APSO would have records or the schedule and the data for all departments, not just my own.
Right. And do you feel that your department has sufficient resources to deal with the access to information requests that come in?
Within the department, I feel like we are adequate. I mean, again, it does depend sometimes on the volume for a specific request. Most requests are relatively straightforward and relatively easy to process. Some can be more complicated, but that's probably a question probably better placed for APSO because they are the ones that have to deal with not just my files, but all of government's files in that processing stage and the communication with the applicant. So it's probably best a question for them.
Okay. I think I'm good for now, Chair. Thanks.
Okay. Hal Perry.
Thank you very much, Chair. And Erin, thank you very much for coming in today. Part of the reason I wanted to see you in here today was you and your department were mentioned, or you were cited in the order, and that the issue is current. So a lot of my questions have already been asked. I'm going to ask you again just for a little bit more maybe elaboration on it. And it goes back to your department's violation of Section 8 of the FOIP Act. And what were the reasons for the unauthorized delay in the request made by the two applicants?
I will say there were two requests that would have been delayed simply because of the transition, that they were on the desk for me to sign when I assumed my role. I believe that there was also an issue with one of the earlier requests. I'd have to go back to grab that information, but I believe that there was an issue in terms of the processing that they had believed that they had requested additional time to process the records, but that the privacy commissioner hadn't granted them that time. But I would have to go back through kind of the timeline to give you those specifics on that one.
Hal
Thank
Perry.
you. I think a request was made, and the commissioner granted a 2-week extension. And within that 2 weeks, there was no reply to the third party. I think it was 20 days after. So can you just explain why that delay? Why they weren't, any information was not disclosed to the third party within the 2 weeks?
That would something that would be normally the responsibility of APSO. So I can certainly go back to APSO and ask them that specific question. But again, that would have predated me, and also it would have been something that was conducted by APSO.
Hal Perry.
Okay, the privacy commissioner had, in the order, looking into this matter, said the reasoning for economic growth, tourism, and culture, keeping the missing information from the applicants, in their words, was remaining a mystery. Can you kind of clear up what that mystery might be today?
In terms of why it wasn't disclosed to applicants initially?
Well, basically what she said was, Privacy Commissioner, the Information and Privacy Commissioner's order looking into this matter said the reasoning for economic growth, tourism, and culture, keeping the missing information from the applicants remains a mystery. And I just wondered if you would be able to clear up on behalf of the department what that mystery might be.
I wouldn't be able to speak to the 3 that were initially disclosed prior to my time. To the 2 ones that I did sign off on, as I kind of had mentioned in kind of previous questioning, I had looked at previous decisions, letters that had gone out. The ones that I had drafted that had been sitting there for me to sign were in keeping with that, and that's why I made the decision to sign off on those letters. It wasn't a specific decision to say, oh, let's not tell people this, but simply it was just a fairly standard template letter, and so I did make the decision to sign it and to get the records out. As I had indicated, they were at that point late anyway, so I wanted to make sure we didn't have further delays on that.
Chair.
Hal Perry?
Yeah, thank you, Chair. So again, we're gathering information because, you know, some of the witnesses, we have a lot of information that have come through this committee, and all of it, including what you will tell us today, will go into making recommendations to the legislature to hopefully strengthen the record management and retention process here. And so I'm just trying to learn what happened so that those same mistakes don't happen again, basically. So why was there a delay until July of 2019 to inform the applicants? I'm going to go back again. I think this question was already asked. I'm going to ask it again. To inform the applicants that the records that they were seeking were missing. Why was that delayed in July?
At that point, we were going through, as I had indicated, kind of that review process. So it would have been, at that point, basically through early June to mid-July. We were doing, from myself, in terms of the steps that we were taking, was a lot of that communication with ITSS. Before we responded back, I wanted to understand as best I could what steps had been taken to recover them, if they could be recovered, et cetera. So really it was time spent working through that process to make sure that I understood before we responded back. At that point, other than knowing that there were gaps, I didn't know why there were gaps. I didn't know if they could be recovered or whatnot. So it was really that time, which would have been, approximately 5 to 6 weeks, that was spent in part of those conversations of making sure that when we did communicate, I actually knew what we were communicating.
Hal Perry?
Thank you, Chair. I think in the media, you were quoted as saying the delay partially was due to staffing shortages. Is that correct?
I would argue I've probably never been quoted in the media talking about records, but
someone from your department put that out into the media, or was it a release from your department stating that staffing shortages may have been a partial reason why these were delayed?
I wouldn't know. It wouldn't have probably come from our department. I wouldn't have spoken to it in the media. It wouldn't be something that we'd put a release out in. I would say in terms of some of the delays that are experienced in terms of processing records, it wouldn't be, again, to kind of Peter's earlier point, it wouldn't necessarily be that our department is delayed, but it would be in APSO. I know they do have quite a heavy burden right now.
Hal Perry?
And so is your department, do they have any staffing shortages at the present time?
In terms of records?
In terms of anything within your department at the moment?
I would say we're always pressed and we could always use more resources, but certainly in terms of records retention, we are now fully staffed on our RIM coordinators. So as for instance, there was a vacancy for approximately a year within our department on a RIM coordinator. But as it relates to searches for FOIP, it's typically, like, it's not one person's job within the department to conduct all of the searches. So in one instance, I may be going to, you know, a certain staff member who would be custodian of records related to tourism, someone else in loans, someone else in immigration. So with the exception of one particular individual who you've already spoken to, who's an employee of our department, typically it's pretty well dispersed across the department to conduct those searches. So it wouldn't be a staffing shortage on that end in terms of inability to meet those deadlines.
Corey Deagle?
Thanks, Chair, and thank you, Erin. I just want to I think Peter and Hal kind of touched on some of these questions, but in terms of the delay in releasing the records and that deadline that was missed, I'm just wondering if you could kind of go through those different steps of kind of what led to that delay and the different decisions that were made. I know some of those decisions are listed in the order, but
So for those two in particular, of the five, frankly, I'd even have to go back to check and see how late we were on it. But you know, certainly I was appointed, I believe, like May 10th to my position. The following week, I was kind of popping in and out a little bit to the office. I hadn't actually officially started until the 21st. So in that first week, I would have kind of had people set up some times to actually talk with staff about the searches, et cetera. And then it would have been that following week when I had kind of gone through all of those steps that I would have signed the letter and it would have gone out the door. Is that more or less what you were looking for? And
yeah, I guess maybe, and perhaps I think you might have answered this, but there's been a number of questions. The reasoning of why the documents weren't released when the deadline was, when that date, why the delay?
So in terms of the actual documents going out the door, it would have been primarily just that transition period. I'd have to go back to check and see when they should have exactly gone to the applicant. There may have been some delays immediately prior to me taking office as well. It wouldn't have been a significant period of time, but frankly, it would have been beyond the prescribed timelines in the Act. So I will certainly grab that information for you, and I don't mind following up and providing that. But then in terms of the delay of why we didn't, between that point and when we disclosed that there were gaps, is that more where you're?
Yeah, no, I think that was kind of what I was looking for, and I know from filing a number of these requests in the past, and like sometimes I would get a call from Access and Privacy Services Office to say we might need a bit more time to try and gather the records or whatnot. Are you okay with that? Usually I'd say, yeah, that's fine, that's understandable. Did anyone ever reach out to the applicant to say, we need more time to get these records to you?
I would have to check on that because it wouldn't have been me personally making that phone call. But aside from just having communication back and forth, there are hard timelines that have to be met. You know, certain applicants may be more generous than others, but regardless of the generosity of an applicant, there are prescribed timelines in the Act that we would have to meet.
Corey Deagle?
Okay, yeah, and I guess that's what I was wondering, is if anyone in your department, or I guess APSO, ever reached out to say, we're looking for an extension, and I know there is kind of a process you go through. There's the 30 days, and then you can get, the department can seek a 30-day extension, and then another 30 days for third-party consultations. I'm just curious if, you know, if we knew the deadline was going to be missed, if the applicant was informed, and was it done through email, or did someone just phone them, or do you know what, do you kind of see where I'm getting at?
Yeah, so I will.
If it was kind of, was it a gentleman's agreement to say, oh, you know, we're going to get them to you, they're just going to be 2 weeks late, or they just weren't informed at all?
I will have to go back to APSO and request that specific information. I know they do tend to keep a fairly detailed log of interactions because, again, we do have timelines that we do need to meet. So in their system, I know they would have a log of communications back with the applicant and, again, kind of when that official due date was. So I will certainly grab that information and send it along.
Okay. Peter Bevan Baker?
Thanks, Chair. A few things I want to fill in some gaps, Erin. You mentioned earlier that when I asked about retention schedules within your department, that some do, but there are some pockets without.
Yes.
Could you tell us where in your department those pockets exist and when you plan on filling those gaps?
So I would say there are units that have had RIM coordinators in place. Tourism would be one. The former Workforce and Advanced Learning Department, so Labor and Industrial Relations, Workforce Development Skills, those units are fairly well established with records retention schedules. As I had kind of mentioned earlier, the department proper, so for my unit, immigration, innovation, population growth, those units, we were without a RIM coordinator for approximately a year. So we have had someone in place now for a few months, and she's getting up and running, and we're starting first with a little bit of training with staff as to, you know, what goes into a records retention schedule. But these are pretty hefty documents and a lot of work goes into them. So we're in that process now of trying to kind of triage the department, have it, you know, work with those sections of the department to get that retention schedule. But again, you know, we can't destroy any documents without that, but we do need those types of documents to really get some rigor into our records management system.
Sure.
Peter Bevan-Baker.
In the House, when the motion came forward to establish this committee, your department, minister for your department rather, had plans to do an independent review within your department. I'm wondering whether you know whether that independent review and investigation surrounding this is going to continue, or whether it's underway, or what the plans are there.
It is going ahead. I will say it is going to be handled out of Education and Lifelong Learning, since they are responsible for records management. So it won't be handled by our department, since we are the subject of the investigation. So I believe they're in the stage of engaging somebody with instructions currently, but beyond that, I really couldn't tell you much more at this point as to what that investigation would look like, again, because we're not the ones directing it.
Right.
Peter Bevan-Baker.
Thanks. So I'm now going to try and drill down a little bit in the centerpiece of this, which is the requests that were made regarding that particular employee's records that went missing. And I know you've had a number of questions from at least 4 members of the committee now. And I'm going to quote from section 47 of the Information and Privacy Commissioner's report. She says, so there's a little introduction, and she says, I further find that EGTC, Economic Growth, Tourism and Culture, deliberately withheld this information. Important information, from the applicants, which is a violation of their Section 8 duty, Section 8 being Section 8 of the FOIP Act. She goes on, I would have expected the gap in the named employees' emails to be one of the first facts to be communicated to the applicants following the EGTC's realization that their search could not be properly conducted. Instead, the EGTC provided the few records they had to the applicants and remained silent about the possibility that there could have been more, but that they had not been retained. So the Privacy Commissioner is very clearly saying that this was not an oversight, this was not something that was insignificant, it was a deliberate withholding of the information. You're contesting that in what you have said today. You've said a couple of times that there was a standard form and you felt that this was not significant information. Are you disagreeing with the report of the Information and Privacy Commissioner?
Well, I would disagree with the statement that I don't believe it's significant. So, you know, certainly this is one of those scenarios where, to be honest, it's hindsight is 20/20 for me. You know, these were decisions that I made in, you know, the first week of being in office. The steps I took were to look at, you know, what the letters looked like in previous cases. It was a fairly standard form letter. Certainly knowing what I know now, and certainly with the Privacy Commissioner's ruling, were I to do it again, I absolutely would have and should have disclosed at that particular juncture with those 2 decision letters that there were gaps. I'm not contesting any of those facts.
Peter Bevan-Baker.
So can I ask you, were you deliberately withholding that information from the applicants?
Deliberate implies that there was intent.
Exactly.
So at no point was I sitting there with, you know, my Monty Burns fingers saying, we will not tell them. It just, as I said, these were fairly standard form letters that went out, and I didn't, at that point, notice that there was anything different from the form letter that I was signing versus ones that had previously been signed. That was what I was looking at that particular juncture when I was making that decision, not, certainly having the benefit of hindsight and experience now of saying, oh, wait a second, we should probably mention that to the applicant.
Okay.
Chair Bevan Baker?
We talked a little bit earlier about the letters that were written on behalf of your department, signed off by you, and I think you said, and again, I just want to clarify this, Erin, that those letters were written or drafted by APSO rather than your department?
Are you, just to be clear, are you speaking of the initial decision letters or the submissions in the review?
The decision letters that your department sent back to the applicants.
So those decision letters are drafted by APSO. Typically, it would be, the text of the request would be included in it. There would be a paragraph or a section on what protections were being applied. So we are disclosing the records to you either in full if there are no redactions, or we're disclosing the records to you subject to certain protections such as section 22 or section 14 or section 15. And then the information about the review process. So if you would like to request a review from the Privacy Commissioner, here's their contact information, you have X number of days to submit it. That's kind of the standard form for those letters, and they do come to me via APSO, and I would sign off on them, yes.
Okay, Chair.
Peter Bevan Baker?
Would anybody in APSO be reasonably expected to have known that there was a gap in those records, or would that be somebody only within the department who would have been privy to that information?
I would have to check on what they were aware of at that time. Again, most of that would have predated me. At the time when I had come in, those it was already drafted and sitting there for me, so I would have to check with them to see what they knew at that particular time.
Okay.
Peter Bevan Baker?
It surprises me that an issue like this, where clearly some significant important information is held only within the department that is being subject to the application for information, would not be the principal drafter of the letters going back to the applicants. And I'm wondering whether that is standard practice in your department, and whether you know whether that's also standard practice across government.
It's certainly standard practice within our department, and I suspect it is standard practice across government that APSO, as the coordinator of the process, does draft that decision letter. But again, it is the department that has to sign off on it.
Right.
So ultimately, it's not, I wouldn't hold APSO responsible for the decisions that were made. They are the department and the head of the public body's decisions to make. APSO would be assisting in that process.
Peter Bevan Baker?
I think there's a difference between assisting and being the one holding the pen, writing those letters. And again, if the information, critical information, was not reasonably expected to be held by somebody in APSO, then surely somebody in your department should have provided that information, or at least amended, edited, adjusted, being the one who was the principal writer of that letter. Would you disagree with that?
No, I don't. I wouldn't disagree with that, and I don't know that it's who does the first draft to me is irrelevant. And I think looking back at this, it should have been, if it had not been APSO, it should have been the department that made sure that amendment was made to the letter. Ultimately, that content is the responsibility of the department, regardless of who drafts the letter.
Peter Bevan Baker?
I think I'm okay. Thank you, Chair.
Okay. I'm checking with committee members. I have no one else on my list. If I can check if there's any other questions at this point from the committee? No? Okay, I'm going to take that as, I think, that we have concluded our questions with you. Thank you very much for joining the committee today and for being candid in your response. I do have a couple of follow-up items that I'd just like to confirm as you were going. You had spoken about the training completion rates for record
Yes.
information management, that you would bring that back to the committee.
Okay.
You'd mentioned the number of FOIP requests that you process, which is through APSO. Would you be able to request that on our behalf?
Is there a specific timeline that people would like for that? Because that would be the question.
Okay. I think what I have on here was in what's the average number of requests that you take in a year.
Okay.
So perhaps if we had over a couple of years just to be able to show, that might help.
Okay.
Would that be okay with committee? Yeah. And then the third thing I had was a request to, I'm trying to read my own writing.
I had kind of made
I can't actually read my
mental
writing, that's terrible.
kind of the detailed timeline
Yes,
of those
thank you.
particular requests. and
That
what
makes sense,
communication
yes, with the timelines, because you have hard timelines that are prescribed. So what was the log of the interactions
Okay.
on the timeline regarding this specific? Thank you. Yes, that makes sense now that I can understand what I wrote. So were there any other follow-ups, committee, that we had raised? Those are the three that I had heard during the questions? No? If there is anything else, then what we'll probably do is ask the clerk to follow up with that in writing
Okay.
as a request from the committee to you, just to sort of confirm that as well.
Certainly.
That'd be great. Okay, well, at that time, then we'll take a brief recess so that you can finish your things. We need to have a copy of your presentation if you haven't provided that already for the record.
Electronically fine, because it is on the computer. You're good?
Yeah,
Okay.
that's great. Great. We'll just take a short recess and then come back for any other business. And we're back. As I promised, there is not much left on the agenda. With the completion of the presentation, that's the end of the presentations that are formally scheduled, I believe, for this committee, but the clerk will do follow-up because there was a conversation this morning about a potential follow-up briefing with the Minister of Finance, and that will be pending the correspondence. So there's some correspondence that's going to need to come out, and I would beg your indulgence if you can, as committee members, have a look at that when it comes from the clerk, just to make sure it did actually capture what we covered today, because there's quite a lot of discussion. Is there anything else that we needed to add? No? Okay, Ryan says no. So we're doing okay. On that basis, is there any other new business at this time for the committee to consider when it's working out its work plan?
Chair, can I just check? I thought there was somebody from the Treasury Board federally who was coming in. Is that going to happen?
There's been a request, but I've received no response from the Treasury Board about the possibility of coming in to date.
Okay.
No, it's a good question. So, and we'd heard that just briefly when earlier today, Peter. But no, that's okay. You haven't had time to. And so the other piece, for your reference, is that correspondence that was reviewed this morning included a response from the Minister of Finance regarding the ransomware. Thank you, and sort of from the context of records retention, and at that point she had said that she didn't feel that she should need to come to the committee, and had given some information. Right. So the decision at that point was to actually go back again and make another request with some options in there, including the option to go in camera if necessary. So that's the kind of pending meeting right now. If there's information that comes in from Treasury Board, then that may be something that could be shared electronically versus needing to get together for a meeting. So as I'm not going to be chairing for future, I can't make a commitment on behalf of your regular chair, but what I would suggest is that we ask that the chair of this committee and the clerk then coordinate to get a work plan out to you as soon as possible, given the timelines that you have for this committee and the pending sitting, so that you can move to consideration of report as soon as possible. And if that's okay with the committee, that would be my suggestion. If there's no other new business, however, may I have a motion to adjourn? So moved. Corey Deagle. Thank you very much. Thank you, Chair. We're adjourned.